Welcome to Looking at Legal Stuff. Today we have 5 hearings in a case with a high conflict couple who are back in court for another contempt filed by Dad. He claims that Mom is neglecting the child and refusing to communicate directly with him, and he gets rather pushy with the commissioner when she expresses concerns about Dad's motives. Mom claims that Dad has called CPS on her multiple times, who've always found his accusations against her to be unfounded, and she says she's got the evidence to prove it. What does the commissioner think of this mess? Let's find out. Today's video is a new version of this case with updated graphics, commentary, thumbnail, and voiceover, but there are no new hearings in this video.
Okay, then do we have Joseph, is it Fike or Fick?
It's Fike, Your Honor. Yes.
Fike. Okay, this is 19-300555608. And do we have Anna Manley?
Yes, I'm here.
Okay. And then I don't know, I do see kind of on the underlying matter, you all have had Rhonda Larson, I believe as a GAL. Is Ms. Larson with us?
I believe she's retired, Your Honor.
Okay. We might need to update our records here. She hasn't been actively involved in your case for some time, is that right?
That is correct. Our case ended in 2021.
Yeah. So I'll tell you all what I have in front of me. I know it gets a little complicated, so if I get this wrong, obviously, please jump in. So I have Ms. Manley. It appears you have filed a motion for contempt / to show cause that is set on for next week, August 23rd. What I have on for today is Mr. Fike, you filed a show cause contempt motion to be heard today. And it looks like you filed that on July 27th. And then we also have on the docket a filing for adequate cause hearing to change the parenting plan. So that was filed, I think maybe you both have filed. Have you both filed to change the parenting plan or just Ms. Manley?
I was the one that filed to change the parenting plan custody order. I believe she and her declarations for contempt or her response was to keep it the same.
Okay, so Ms. Manley, you today, and tell me if I'm wrong here, you today are here to object to a finding of adequate cause to change the parenting plan, and then also to respond to Mr. Fike's contempt motion. Is that correct?
Yes.
And then you have also separately from today filed a contempt motion, and that's scheduled to be heard on August 23rd. Is that also your understanding?
Yes.
Okay. All right. So Mr. Fike, first, let's deal with your contempt motion because that is based on the parenting plan that's currently in effect. So I do have your, I believe, July 27th motion. What would you like me to know about your request for a contempt finding?
Well, to start with, so in our parenting plan, we are to communicate with the well-being of our daughter, Liliana. Since about March of 2022, I have been blocked by Miss Manley. She has made it clear. I have attached text messages saying that I'm blocked. I think she actually filed some as well. She uses my dad as a third party, which over the course of that length of time, he has asked several times for her to stop communicating with him because she has done nothing but harassed him and caused him health issues. And I would like that to stop. I would like her to be held in contempt for having me blocked. That goes against our parenting plan. The second one is my daughter, or our daughter Liliana, constantly comes to our house, tells my wife, myself, and my father that she does not like us, that her mother hates my wife, that she has told my wife that my mommy says that you are a bad person, and I would like for this to stop. She uses the word hate. She's 3 years old. She should not know the word hate. The third one, the biggest one, was also to change the parenting, was poor hygiene.
That's
Every
on
time,
your, that's the basis for your adequate cause motion, not your contempt motion, right? Your contempt is based on comments from the child about you and your, I guess, spouse now or partner, and the blocking of you to communicate directly about kiddo. Is that right?
correct.
Okay, let's deal with that first, and then we'll get to the adequate cause, because I did see the dental information supplied in there. So, Mr. Fike, help me out. I have gone back and looked at your July 2nd, 2021 parenting plan final order. I'm not seeing anything in there specifically, but perhaps I just missed it, that states that she has to communicate directly to you about the child, or that she can't use a third party. I'm just stating that I'm seeing under other orders what was typed in, which is pretty common in parenting plans, is that the child has to be able to freely communicate with the other parent. Each parent has the right and responsibility to ensure the child attends to school, etc., can schedule extracurricular activities. I do see a comment about neither parent will make or allow others to make negative comments about the other parent. Neither parent shall ask the child to make decisions or requests involving the parenting plan. You're not supposed to discuss the parenting plan with the kid. And then if there's an intent to remarry or establish a new live-in relationship, you can't expose the kid to those until the relationship's been going on for 6 months or more, etc. I'm not seeing, and again, please point me to it if I'm missing it. I'm not seeing anything that precludes her using your dad or any other third party to communicate with you if she wants to not have direct communication. So help me out.
It's just my understanding that, we were to have direct communication for Liliana. When we have issues, when she comes to my house, I have no way of contacting.
Yeah.
Like, my dad has sent her messages and she makes threatening messages or derogatory comments towards him. He's 65 years old and does not want to deal with this stuff. He's not a part of it.
Yeah. So what I'm going to do on your first reason for contempt is deny it. I don't even need Ms. Manley to respond to it because it's not in your parenting plan. Here's the thing. I understand your frustration. So on just a personal level, I can absolutely understand how it is difficult to communicate when one parent won't communicate with you directly. But a contempt motion is asking me to find that there's been a direct violation of a final order of this court. And I can't find that just based on my review of the 2021 parenting plan. Ms. Manley's behavior, although unhelpful, is not contempt. So let's move on to the second reason you have filed for contempt, which is the negative comments. Ms. Manley, what can you tell me about that? And let me start with just reading what the 2021 parenting plan says. It says neither parent will make or allow others to make negative comments about the other parent or the other parent's past or present relationships, family, or friends within hearing distance of the child, nor shall they allow the child to make disparaging remarks about the other parent. So you've heard Mr. Fike's statement about things child may be saying when they are with him. What would you like me to know?
I would like you to know that I have not made comments about Mr. Fike or his wife to Liliana because she is 3 years old and she loves them. It would hurt her feelings if I said anything like that. And I'm not going to go out of my way to hurt my 3-year-old daughter's feelings on purpose. I filed a screenshot from January 20th of this year, where I was telling Mr. Fike that she was saying the same thing to me. Daddy doesn't like you, you know, Titi doesn't like you. And I sent Mr. Fike a message saying that I'm not okay with that. And if it continues, I will file contempt of court on him because I do not take that thing lightly. So what Mr. Fike has done is simply turned it around on me. I have at no point in time spoken badly about him or his wife to our daughter.
I have reviewed the documents that were filed as part of this request, and I'm going to deny the motion for contempt in total. Number one, I've already stated my reasons for denying it on the first issue. I just don't, I think I can't find more likely than not that Ms. Manley is the reason that these comments are being made by a 3-year-old. And I'll be honest as well, the court typically, so out of court statements made by a 3-year-old are typically excluded from the court's reliance on the truth of the matter asserted under a child hearsay rule. So absent some other evidence that directly would link Ms. Manley to derogatory statements about Mr. Fike or his new partner, I can't find that there's a direct violation, a direct and knowing violation of the parenting plan. So I am going to deny Mr. Fike your contempt motion. What I'd like to do at this point, though, is move on to your request that this court find adequate cause to change the parenting plan. And the court obviously takes into account statements you've already made for purposes of the contempt hearing, but it sounds like you do also have some additional evidence you would like the court to consider.
In addition to,
Go ahead. So it sounded like you wanted to talk to the court about some of the medical concerns you have with regard to your request that I find adequate cause to set this on for a trial to permanently change your parenting plan from 2021.
yeah, so the poor hygiene. So on August 30th of this year, in about 2 weeks, our daughter Liliana is going to go to the dentist to have 6 cavities filled, 1 for sure root canal, and possibly 2 root canals. And this is due to bad hygiene from the doctor, the dentist telling us so. I filed the findings with the court from the dentist. They are also in compliance. They said that any additional information that the court needs, they will provide that for you. The rashes and the bug bites are constant. Every time Liliana comes to my house, she has a rash in her downstairs area. Now, when she's here on Fridays, we're able to put rash cream on it. By Sunday, it's completely gone. Wednesday nights, we put rash cream on it. We've communicated through my father. Any other communication can't happen of her having to, take care of our daughter and the hygiene, and she does not comply. It is constant. So recently I had a vacation week with my daughter. There was a doctor's appointment that we were going to take her to on August 1st. Upon arrival, that doctor's visit was canceled by Miss Manley. The Kaiser Permanente was very confused as to why it was canceled, because according to their records, my daughter has not seen a doctor in over 1.5 years. The Child and Adolescent Clinic has kicked her out of their facility due to canceling appointments, not showing up to appointments. And I'm waiting for documentation on that. They said they have 14 days. It's been about a week or so now, so it should be any time I should be receiving those. I just got her in for her 3-year well child exam. Next month she goes in for a 4. I think all this shows that Miss Manley is not caring for our daughter on a regular basis. She has called CPS on us, saying that we have infestation of bug bites, when we have pictures that I have filed with the courts, and CPS has seen that those bug bites are not coming from our house. There are text messages from Miss Manley saying that they are coming from her house and that she has taken care of the problem, which obviously hasn't, because it continues. I have a picture of methamphetamines that Miss Manley is holding in her hand. That was a text message from her neighbor's ex-boyfriend that apparently her son had picked up and given to his mother. The neighbors constantly complain about the way Miss Manley is treating my daughter and her older brother. There are statements that have been filed with the courts. Miss Manley says that they're a year old, which I don't understand since the dates are clear on there, and numbers that we could call either one of those witnesses, which are directly next door to Miss Manley. CPS is involved with this case. They are going to be filing or coming back with collateral very soon. We're waiting on that.
And what do you mean collateral?
I was a little confused by that. I think it's a statement on what they found.
So meaning, and that's not something you have filed with the court. So are you saying that there's an open investigation by CPS into Ms. Manley?
Yes.
Okay. And you believe something further is going to come of it?
Yes. In fact, my text message from her says that she will follow up with collaterals. She's advised me to come here to court today with my pleadings and findings, and that she will follow up with collaterals.
Okay. Let me hear from Ms. Manley. Ms. Manley, what can you tell me about any knowledge you have of a CPS investigation?
This is about the 3rd or 4th CPS investigation that I've had on me. The previous 3 were found false, and they were closed down immediately. Mr. Fike has called them on numerous occasions with nothing but blatant lies. At one point, he called them and told them I was burning her fingers to punish her. I had a sheriff officer show up here with CPS lady. They came into my home. They checked out Liliana for bug bites, bruises, burn marks, etc. They found nothing, and the case was closed the same day. That was in February. I've had another time he called CPS on me and told them I was doing meth. I took a drug test. I passed it. That case was also shut down. It's been ongoing calls to CPS from Mr. Fike, and they've all been unfounded. CPS showed up at my house last Friday again. And she told me that Mr. Fike was accusing me of doing drugs again. I submitted a drug test on the spot. The results should be back in 1 to 2 weeks. They will also be negative. I live in a transitional housing program run by the community house on Broadway. I've lived here for 4 years now. Mr. Fike lived here with me last year. So he's well aware of the fact that we do weekly drug tests here. We have mandatory reporters that show up to do house visits at random. They constantly keep check of their children's welfare, the state of the home, all that. I have never had a warning, nothing.
Here's what I'm going to let the folks know too. I have reviewed the declarations, Ms. Manley, that you filed in response to some of these allegations. I went back and looked at the 2021 Guardian ad litem report. Mr. Fike, I'll be perfectly upfront with you. Several of the allegations that you're lodging now against Ms. Manley, you also lodged in 2021. And the guardian ad litem at that time stated that the allegations against the mother and her mental health are unfounded. And according to the investigation by the GAL, the natural mother takes good care of the child. As a result, and I've read the entire GAL report, when the GAL looked into this matter, essentially found that neither one of you would be deemed inadequate parents, hence the parenting plan that was put into place. The history I see in this case since that time is just serial contempt filings and continued allegations about the same behavior that was already investigated and deemed not credible. The only thing that kind of raises my eyebrows and probably keeps me from making a ruling today is an open CPS investigation and a drug test. So what I'm going to do, because we already have you folks on next week for August 23rd at 9 a.m. for Ms. Manley's motion, I would like to, I'm going to reserve ruling on the adequate cause request by Mr. Fike. So Mr. Fike, that means I'm not granting or denying your motion today. I'm asking for more information. I don't know if we'll have that information by next week at 9 a.m. But what I would like is if Ms. Manley, if the drug test you just took does come back, please file that with the clerk of this court. I would like to see those results. And then Mr. Fike, if you do get additional documentation from CPS, please file that with this court. I would like to know, if CPS finds this latest allegation unfounded, I want that. If they believe that there's further follow-up or whatever this collateral is, I want that. So I'm simply reserving ruling for additional information. Do the parties have any questions for me?
Yes, ma'am.
Go ahead.
I'm a little confused. You say you went back to 2021. All of this that I've filed recently in this case are things that have been brought to my attention. Okay, the blocking.
Mr. Fike, hold on, let me be very clear. In reading the GAL's report from 2021, I understand you're alleging new dental issues. I am taking that into account. I'll also tell you, 3-year-olds with dental issues, very common, see it all the time, and it does not necessarily mean that any sort of neglect or abuse has occurred. I need something more than that if I'm going to find adequate cause to change a parenting plan. What I'm telling you is, in reviewing the report from 2021, you at that time were alleging drug use, you were alleging rashes on kiddo, you were at that time alleging other medical conditions, including constipation, you were requesting mental health evaluations of Ms. Manley. All of those things were deemed unfounded when investigated in 2021. So while you may be bringing up some additional new factors, I'm telling you, a lot of this appears to be a rehashing of things the court has already ruled on. So what other question do you have for the court? And I hope I've been clear about what I want from you, which is any follow-up from CPS into this latest call-in that you've made on Ms. Manley, and I want the drug test results before I make a ruling.
Right. So everything that you brought up as far as the 2021, all those allegations were from Miss Manley to myself. I had to go take a hair follicle test.
I understand that's not true, sir. Actually, in the report, the GAL had concerns about your allegations against Ms. Manley and specifically stated the allegations against the mother and her mental health are unfounded. And according to the investigation, the natural mother takes good care of the child. I'll also tell you that the GAL found that the child was well cared for with both of you. Okay, so this is not one-sided. The reason your parenting plan was adopted the way it was is that the GAL found both of you were doing a good job. Okay, so I've told you what I want to see next week. If we don't have it next week, we can talk about what date we expect to get that evidence. But standing here right now, I do not believe there's enough evidence for me to rule on your request for an adequate cause motion. So we are going to set it over to next Wednesday, September 23rd, when you folks are already scheduled to be here. Are there any other questions for me?
Is it possible to make it to where I can get Liliana into a doctor and make sure she gets to her dentist appointment? Kaiser won't even see or talk to or communicate with her mother because she constantly, she constantly, I'm just, sorry, I'm having a hard time with this one.
Okay. Ms. Manley, is there a reason that you can't assist in getting child to the doctor and dentist in short order?
I have no problem getting her to the doctor or the dentist, and I have no problems with Kaiser whatsoever. I've never missed an appointment there. And I'm the one who set up the Kaiser visits to begin with.
When is the next, when's the next either one of you can answer this. When's the next doctor or dentist visit scheduled for child, or do you have a date scheduled?
Her next doctor's appointment is September 1st. However,
is that at Kaiser?
yes, Liliana has only been seen once at Kaiser, and that was when I took her. The only other appointments she's had was over a year and a half ago with the child and adolescent clinic. Again, they had booted her because of canceled appointments. I have that documentation coming, and I will be filing that.
Please do. So child has an appointment with the doctor on September 1st. Whoever child is with on September 1st, I expect that appointment to happen. I don't want to see a canceled appointment on September 1st. Is that clear, Ms. Manley?
Yes, ma'am.
Okay. And then do we have a dentist appointment scheduled?
Yes, she has oral surgery on August 30th.
Okay.
And I have been requested by the dentist to be there with her.
Okay. And where is that taking place?
Harbor Kids Dental right here in Longview.
Okay. So Ms. Manley, on that date, even if that is a scheduled date where you have child, I am going to approve Mr. Fike to be the responsible parent for taking her to that surgery.
That's okay.
Okay, is that understood?
Yes.
Mr. Fike, it's that is your request and it works for you, correct?
Yes, ma'am.
Okay. Okay, anything else folks need from me before next Wednesday when I see you back here at 9 a.m.?
No.
How much can be filed?
Sorry, say that again.
Like how much more can I file to prove that she's in contempt? And
well, the contempt motion I've denied based on the 2 reasons that you filed your prior contempt motion. So if there are new reasons for contempt, you would need to file a new motion and you can submit whatever evidence you want for those new findings of contempt. What you can supplement now, because I'm reserving ruling on, is your request that I find there's adequate cause to change the parenting plan. So that is what the court would accept additional filings on right now without you having to file a new motion.
okay.
Does that make sense?
Yep.
Okay. Ms. Manley, any questions for the court?
No, Your Honor.
Okay. Thank you both. We'll see you next week. Okay, I'm going to move to number 4 on our docket. Joseph Fike, I see you there. Anna
Yes,
Manley.
I'm here.
Okay, so this is 19-300555608. Let me just get into your digital file here. Okay, so when we were last here, we were addressing Mr. Fike's motion for contempt. We did deny that, but we did reserve ruling on the adequate cause motion to today. And then my understanding is also if I am correct, Ms. Manley, you have filed a motion for contempt. Is that correct?
That's correct.
Okay. So let's first address your motion for contempt. I'm just gonna go get your original motion here. And Mr. Fike, have you had a chance to review the motion for contempt that Ms. Manley filed? It was on or about August 7th.
Yes, I have.
Okay. So Ms. Manley, what I see is one of your initial requests is back child support in the amount of about $5,850.
Yes, that will be paid to the state because I've been on TANF. So technically he owes the state that money.
Okay.
But I would like Mr. Fike to resume child support payments so I can get off TANF.
Mr. Fike, just as it relates to, hold on one second. I have someone messaging about some additional people in the waiting room. I'm going to let them in. Okay, so Mr. Fike, as it relates to child support, what can you tell me? Just as it relates to, all right, if you just logged in, please mute yourself. Okay, Mr. Fike, we can't hear you if you're speaking.
No, I was waiting for the interruption.
Okay, go ahead, sir.
So as far as the child support, back in December of 2021, Anna sent in and signed a piece of paper to child support, which discontinued child support from myself. It was my understanding that this was the end of it. I do believe that she is just filing this because I filed for contempt. Like she said, she is on TANF, so she's not actually receiving any money. I know this was one of the reasons she stopped payment from me. So as far as I knew, it was already written off and done. I didn't know that I was supposed to call child support to resume so, since she had already stopped it.
So Ms. Manley, do you have something showing amounts from child support that are owed?
Yes, I believe it's 5,120. No, I don't know the exact amount.
No, I'm asking something, since it's not owed to you, that it's owed to, that child support is collecting it. Do you have something from them showing the current amount that's due?
I have it somewhere here, but I do not have any in front of me. The reason it got discontinued is because Mr. Fike was living with me. So I assumed that once he moved out that he would resume paying child support, but he did not.
Your Honor, this is Casey Looney with the state
Yeah.
again.
Go ahead.
We were just looking into this case as Ms. Manley was speaking, and
Right.
the state will need to be filing a notice of appearance in this case. So we'd be objecting to any discussion about child support at this time. It does appear that TANF is still active for mother and children, so we would need to be looking at what the support looks like and where those payments need to go. There are arrears owed to the state of Washington for TANF at this time.
Okay. I think that makes a lot of sense, and I'm glad you happen to be on docket for that, because it does appear, I guess what I'm going to say right now is, given the state's involvement and the issues with whether when he moved in that should have ceased and whether he moved back out, it should have resumed. I'm not going to make any ruling on, I'm going to reserve on Ms. Manley's motion for contempt, and we'll set that to a new date. How much time would the state want to get involved and present any position to the court?
Your Honor, if you could give us a minimum of 3 weeks, I would need to review the case and be able to draft proposed orders and get those out to the parties.
Yeah, let's go ahead and set the issue to September 13th at 9 a.m.
Thank you, Your Honor.
Okay. And then what I'm going to do is also set over the adequate cause showing to that date. So Ms. Manley and Mr. Fike, you're probably going to receive between now and September 13th. You're going to receive some additional information from the state on the child support issue. So please be on the look for that. If there's something you disagree with, please file something before September 13th, letting me know with documentation, if possible, why you disagree with it, okay?
Yes, ma'am.
Okay. All right. Thank you all for being here. Ms. Looney, thanks for your input.
Thank you, Your Honor.
Okay. Let's move to our contempts. I'm going to call, we've got numbers 4, 5, and 6 on the docket, all involving Mr. Fike and Anna Manley. Just going to take a brief pause here to move our computer systems down. Okay. And I want to just initially, well, first, let me ask Ms. Manley, are you able to hear the court?
Yes.
And Mr. Fike?
Yes, ma'am.
Okay. So it sounds like, and I know y'all have been here many times. What it looks like I just was handed this morning is a declaration of Anna Manley that was filed with the court yesterday. And it states that Mr. Fike had filed some additional documents on perhaps September 11th, which would have been Monday. So let me first ask, Mr. Fike, have you received the September 12th declaration from Anna Manley?
Yeah, I received that last night, Your Honor. And what she's referring to is what I filed the previous week. I believe it was Wednesday or Thursday is when I filed it in the court. And it was just 2 declarations and some text messages. And she's saying that she didn't receive the text messages. Well, she actually filed those same text messages herself. So I didn't feel the need to give her the same. It costs, about $30 for a cartridge of ink. And I've gone through 4 of them in this whole process so far. So she knows what text messages they are. It was filed last week. I turned in the form on the 11th. Of proof of service, I believe it was.
So Ms. Manley, the document that he said you served on September 11th, that you were served with on September 11th, that he filed September 6th, did that contain new information that you were not previously aware of in any way?
No, but it also said that in his declaration that he filed with a letter from a dentist. I also never received that. And I never received the text messages he filed either.
So you don't have the letter from the dentist?
I do not.
I also just want to ask Mr. Fike, it sounds like you have a phone conference with one of the doctors today.
That is correct, with social services as well.
Okay.
At the request of her doctor.
Yeah. Is it your understanding that you may be providing additional evidence depending on the outcome of that meeting with the doctor?
I would assume so. I'm not really sure what it's about, Your Honor, and I can explain that a little bit.
Go ahead.
On August 31st, I received a phone call from Kaiser. It was the same lady that does the appointments for Kaiser. She told me that Anna had called her and demanded a call back from them. And she called me because I was the first number that was on there and wanted to know what it could possibly be about. I told her that it was probably for the immunizations that Liliana is due for. And I assumed she was making an appointment for that, considering that's what appointment that section is for at Kaiser. Well, about a few minutes later, the same lady from Kaiser called me back and said that after that conversation, the doctor would like to set up a meeting with myself and social services about what is going on in the mother's home. There was no explanation of exactly why. The only reason it's today is because that's the first time that we could get in for an appointment. In her declaration from last night that I read, she said that she spoke to the doctor yesterday, which I know that's not possible because you can't just call a doctor's office and talk to a doctor. You have to make an appointment with them, especially at Kaiser. They're a very busy doctor's office.
Okay.
So that was a little confusing.
Yeah. Well, here's my take on this. We've got some very late filed declarations. But the reason that I want to set this to a new date is not to delay this in any way, but because I believe that your conversation directly with the doctor today may provide pertinent information that actually advises this court. I feel like right now I'm getting a lot of filings just from the two of you that are a little bit, he said, she said. My hope is that out of this conversation directly with the doctor, that perhaps something from the medical professional could be provided directly to this court that gives the court some clarity on what is happening in this case, so that I have some more objective grounds with which to decide these contempt hearings. So what I would be asking Mr. Fike, I think in the benefit of your motions and Ms. Manley to the benefit of your motions, is that you hold that conference with the doctor and we renote this for our next family law docket, which since we don't have it next week, which would be September 27th at 9 a.m. And then please file whatever you get from the doctor out of today's conference.
Okay, so all of the stuff that I filed last month after our
Yes.
first court date,
Yep.
has that been looked at?
It is all, I have all three of the motions. We have your show cause, her show cause, and the adequate cause. So we have all of it.
Right, so mine was, the contempt was you dismissed my contempt.
Correct.
But,
Your first one.
right. And so the other one that I had and I filed with that was the neglect out of the mother's home. And I filed lots of doctors' documentation from child and adolescent clinic showing that my daughter was being neglected for more than a year with dates and everything on it. And also that she had not been seen by a doctor in over a year and a half, and longer than that from being taken by her mother. And all of this is very alarming. I constantly get my daughter with rashes, and it's all to the point of
Mr. Fike, I'm trying to help you here because we did talk about this. When you had a GAL involved in your case, there were very similar allegations that were ultimately deemed unfounded from both sides. What I am asking for, and so what I'm telling you without trying to give you legal advice is, right now still there's a lot of self-serving statements being made by both parties about what is happening with child. Because you have this great opportunity to speak firsthand with the doctor and social services, I would like to hold off on a ruling until I know what their opinion is on child's welfare and safety. And I think that's in child's best interest. And I think it's in the best interest of both of your motions. So that is why I'm saying your prior motions are not, or your prior filings are not being disregarded. I am asking for additional input from these experts before I make my ruling. Okay.
Yeah, I understand that. What I'm trying to get at was with those filings that I put in before, it shows the neglect from the doctor. All those, so,
I understand that's your opinion of what it shows. So what we're going to do when we come back on September 27th is we will hope to have additional information, current information from the doctor now that the doctor has spoken to both of you, which I think is very helpful, and with social services involved. And then please get that filed with the court, whatever the outcome of that may be. We will push this to September 27th, and we will do the contempt hearing and the adequate cause hearing at that time with that additional information. If we don't have it, hey, at least we gave you all a shot to get it. We'll still move forward. I'm not going to bump you out again, but I would like to have the opportunity to receive that input directly from the doctor.
okay.
So does Wednesday, September 27th at 9 a.m. work for the two of you?
That's fine with me.
Okay, I appreciate you getting that conference scheduled. I think it will be helpful. What I would like to do is state, no additional filings except for what may come out of that conference, just because I don't want to be in a position on the 27th of these filings being made 1 or 2 days before the hearing and then someone asking for more time. So the only filings I would expect before the 27th are documents that come out of today's meeting with social services and the child's doctor.
Yes, I will make sure those are filed tomorrow.
Okay, great. I appreciate you guys working on this, and we'll see you back here in 2 weeks.
All right, thank you.
All right, thank you. All right, so next in time on my docket, it's numbers 6, 7, and 8 together. This is Anna Manley and Joseph Fike. Give me just a minute to pull up all of your case numbers here. Do I have Mr. Fike and Ms. Manley?
Yes, ma'am.
I'm here.
Okay, there you are. You're on my second page of Zoom participants. Just a minute here as I get into your files. Okay. So let's first talk about the adequate cause motion. This is an instance where when we were together last, I did not make any specific ruling on that because Mr. Fike, you indicated that same day when we were last together, you were having a conference with Kaiser and social services. And you potentially thought that you might be supplying information to the court after that conference. I'll just let the parties know that the only thing I've received since then is a declaration affidavit of Ms. Manley regarding her interactions with the social worker from Kaiser and correspondence from CPS stating that any investigation into Ms. Manley is closed with no findings regarding the allegations. Is there anything else I should have, Mr. Fike? Did you intend to file anything?
Well, I intended to, but when I spoke with the doctor that evening, he told me that he was going to have social services call me, and that never happened. So I called social services. They told me that the doctor can't get them to call me in a case for whatever reason. Anna indicated that she talked to social services at Kaiser. There is no social services at Kaiser. I spoke with them and confirmed that. So there has been no social worker involved. The case of CPS was closed. And as far as I was told with my conversation with CPS, that was actually the findings from my house. So it doesn't actually indicate where the case was being closed from in that letter. It just says that it was closed. And when I spoke to CPS, the lady told me they were the findings from my house. So I'm not really sure. It's all very confusing.
Okay.
I've been canceled 3 times now by the doctor in trying to have a conversation with him to find out what's going on. And apparently Miss Manley has been able to get a hold of him, but I have not.
Okay. So Ms. Manley, go ahead with anything you would like the court to know. I'm just first dealing with Mr. Fike's motion for adequate cause to change a parenting plan.
I had the social worker from Kaiser, she called me and we talked about the whole situation, and she said her only concern was Mr. Fike's behavior. And as far as the CPS report goes, that's the findings from the drug test and the investigation to my home that they did because of Mr. Fike's allegations.
So I have reviewed so I have reviewed the filings from CPS. Mr. Fike had indicated he thinks that these are related to any investigation on his home. I don't find that to be accurate. I find that it's specifically addressed to Ms. Manley and indicates that her case is being closed with no findings regarding the allegations. I also understand Mr. Fike is asserting to the court that there is no social worker at Kaiser. I don't find that to be accurate, as there are text messages from the Ms. Childs, the quote, social worker from Kaiser, specifically to Ms. Manley. So I think the totality of these circumstances, in addition to the prior concerns I've had with regard to Mr. Fike re-raising allegations that were already addressed by a GAL, is that I am going to deny the motion for adequate cause. I have filled that out. I'm specifically making a finding that there are not valid reasons to hold a full hearing or trial on the petition. The petition for adequate cause should be dismissed, and I have signed an order to that effect. So we're not going to hold any further hearings on the adequate cause motion. Oh, maybe I'll just. So let's move to contempt. When we were together in prior hearings, I'll just note specifically that Mr. Fike had moved for contempt findings against Ms. Manley. I had already denied that finding. They were not violations of the parenting plan. However, there was a contempt motion by Ms. Manley alleging back child support. What I have received is a response from the Cowlitz County prosecutor indicating that the child support arrears are owed to the state of Washington and not to Ms. Manley. So, Ms. Looney, are you taking any position beyond what was already filed on August 29th?
No, Your Honor.
Okay. And I assume the state is not filing its own or has not filed a motion for contempt at this time.
We have not, Your Honor.
Okay. So Ms. Manley, I also, because of the state's filing and that the arrears are actually owed to them, I do not find you would be the proper party to bring this action. Therefore, I am going to deny your motion for contempt against Mr. Fike as well. Do the parties, as far as I can tell, that takes care of all the issues that have been in front of me for the last few weeks. Is there anything else the parties believe hasn't been addressed that you have previously filed and asked the court to address?
Yes, I also filed contempt regarding my attorney fees that was put in place on 6/7/2021 that Mr. Fike owes me with interest that's now up to $1,240. There's also the matter of fact that he withheld Liliana from me on 8/30.
Let me get to the attorney fees. I'm not seeing. Oh, it's included in your child support contempt order.
Yes.
Well. Give me a minute to get to the final judgment. Mr. Fike, have you reimbursed $1,000 in attorney fees?
No, I didn't know I was supposed to. When she filed that, that was the first I had heard of it. I never got any email indicating that I owed anybody money.
I'm looking to see, Ms. Fike, what's the date that you indicate the judge ordered?
It was 6/7/2021.
This was a contempt hearing.
The only thing, Your Honor, I was given at the end of that trial was after the order, her attorney had filed for additional reconsideration, and that was denied by the judge. And that's the only thing that I've received after the fact.
Yeah, so Ms. Manley, I'm gonna deny that request, and it's not because I don't think that he doesn't owe you the $1,000. But what you're referencing in 2020 is a contempt order. So the court has already ruled on this issue. They held a contempt hearing on June 7, 2021, and specifically made a finding that he was in contempt for failure, or excuse me. Yeah, they actually stated he was not in contempt, but they awarded you $1,000.
Was I there for that one? Because I don't remember that.
6/7/2021, yes. Parties present. Ms. Bliss was the attorney, I believe, representing Ms. Manley. You were present as the petitioner in the proceedings. Your guardian ad litem was there, and there was a deputy prosecuting attorney there, Ms. Wade. Okay, so I'm going to go ahead and deny Ms. Manley's motion, but Mr. Fike, that 2021 judgment is there. There was an actual contempt hearing already on that issue. Okay.
Okay.
And then Ms. Manley, you said your other contempt hearing or contempt motion is based on Mr. Fike withholding Liliana from you on, is it August 23rd?
It was August 3rd.
Sorry, that cut out.
It was
You're continuing to cut out.
there, sorry. It was on August 30th when he was ordered to take her to get her dental treatment done. And the treatment was not done that day, and instead Mr. Fike took Liliana to his home and kept her all day.
I am also gonna deny this motion for contempt. In reviewing the pleadings, it does not appear that this has been an issue that has recurred, and it looks like Mr. Fike's likely explanation through his filings was his concerns about her safety and welfare. I'm not condoning the behavior in any regard, but I'm not going to find that it was done in bad faith. So I am going to deny. But what I'm going to say is I will entertain future motions for contempt if, now that Mr. Fike is aware that this court has specifically made findings that Ms. Manley is not in contempt, CPS has closed their investigation, and it appears from everything I have that the doctor's office is actually concerned about Mr. Fike's behavior, not Ms. Manley's behavior. If there are further incidents where Mr. Fike is not adhering to the parenting plan, I will entertain motions for contempt. Okay, anything else the parties need addressed on your matters?
Well, it is, I don't know if it's contempt per se, but I do have some issues with Mr. Fike trying to alienate me from Liliana's doctors.
Right, so let me just say this. This court is not in a position to solve every unfortunate family dynamic. I don't have a motion in front of me that in any way addresses. I have allegations that you believe that the doctors have said that he's alienating you from her care. If you want to file something that's an actual standalone motion for contempt on that issue, we'll address it, but that's not in front of me today.
Okay.
All right, thank you both. You're free to log out.
Next, I have Joseph Fike and Anna Manley. This is cause number 19-3-55608. I'll check and see if the parties are present. Joseph Fike, are you here?
Yes, I am.
Okay, welcome to you, Mr. Fike. And I'll ask if Anna Manley is present.
I am here.
Okay, Miss Manley is present. Just a moment. Okay, this is one moment. We're here for Ms. Manley's motion for contempt. It looks like service was effectuated upon Mr. Fike on January 10th, so service appears to be proper. And so I'll hear from Ms. Manley related to your motion, then I'll hear from Mr. Fike in response.
Yeah, on New Year's Eve, it was my scheduled parenting time from 5 p.m. on 12/31 until 5 p.m. on the 1st. Mr. Fike did not bring our daughter back to me. I asked him if he could please bring her back. He said it's his time. I sent him a picture of the parenting plan and explained to him how it works, and he still refused, and he just kept her until the next day. This is the second time he's withheld her from me in less than 5 months. And I just feel like he's not respecting our parenting plan or the routines we have for our daughter, who's only 4, at all.
Right,
So,
thank you. And then one point of clarification, if I may, Ms. Manley, there was some indication that your motion may have included being tardy at exchanges. Are you pursuing that as a contemptuous motion?
no, that was more of a mention that the parenting plan is not being respected, just overall.
Okay. All right. Thank you. All right. I'll hear from Mr. Fike, please.
Yes, Your Honor. So in my declaration, I stated that we agreed with during our parenting plan in 2021 that my holiday schedule was lined up with my other children's schedule. Anna agreed to that. I attached with the courts and my filings a copy of the page of my holiday schedule with my 2 boys, which clearly states that I have even years for New Year's Day. Our parenting plan, as you can see, as Miss Manley has filed, says New Year's Eve / New Year's Day. However, as we all know, the holiday is New Year's Day, not New Year's Eve. And Anna had Liliana last year, as so did my boys' mom had my boys. This year was my year, and I tried to let Anna know that. She sees the parenting plan. We agreed on it 3 years ago. I have no intention on withholding our daughter. This is not the second time I've withheld her. I have no interest in angering Miss Manley with fear of what she might do to herself or our daughter. I'm asking the courts to reconsider this and throw this allegation of contempt out. As you can see, that my holiday schedule is the same as it is with my other boys.
Thank you. Ms. Manley, any response?
My only response is that for the most part, our parenting plan does match the parenting plan Mr. Fike has with his ex-wife, but on New Year's Eve, it does not match. It is 2023 was clearly my New Year's Eve.
Okay, all right, thank you. All right, so I'm looking at the July 2nd, 2021 parenting plan. Therein on page 4, well, page 3 is the start of the holiday schedule. So the holiday schedule indicates on page 4 that it talks about Thanksgiving break, it talks about Christmas Eve, and it talks about, alternating years and even years and the like. So under New Year's Eve, it says New Year's Eve / day begins on December 31st at 5 p.m. to January 1st at 5 p.m. Odd years with Anna Manley, even years with Mr. Fike. So that period starts on December 31st. So anytime you're measuring anything, there's a start time, whether it's a stop clock or a calendar or a running race. There's a start line. The start line here is December 31st at 5 p.m. And that's in the year that it occurs. So in 2023, that was an odd numbered year. So December 31st, odd number year goes to Ms. Manley. I can appreciate Mr. Fike's argument related to the fact that the holiday is July 1st, or pardon me, January 1st. However, that doesn't hold sway, at least in my mind. I think the plain reading of that parenting plan is that the parenting time begins on December 31st and extends into the new year to January 1st at 5 p.m. So the odd years were awarded to Ms. Manley. I recognize there's disagreement in the reading of that, but my reading of it, the clear reading of it, is that that was Ms. Manley's time and she was denied that. I'll make a finding of contempt and then I'll impose a $100 civil sanction. Mr. Fike, you can purge that by abiding by the parenting plan laid out in next year's New Year's Eve, which is actually going to be your time because that's the even year. So I doubt that's going to be an issue. So that'll be the court's order related to today's motion. Any questions from the parties?
Yes, I have a question, Your Honor.
Go ahead.
Instead of $100, would it be possible for me to get Halloween this year as a makeup day?
I'm not going to be involved in negotiations. I'm imposing that the civil sanction, if the parties want to negotiate something, they certainly can, but I'm not going to be involved in that.
Okay. Is there a time limit to when Mr. Fike has to pay that?
It's within 30 days.
Okay, awesome. Thank you.
Mr. Fike, do you have any questions?
Yes, Your Honor. This is not very clear. The holiday is New Year's Day.
So this is
And
not an opportunity to re-argue the case. Do you have any questions about the court's ruling?
no.
Okay, that'll conclude the hearing. Thank you.
Thank you, Your Honor.
That was the final hearing in this case. I was pleasantly surprised to see that it's been 13 months since either of them were in court to complain about the other, and it's my sincere hope that this couple, but especially Dad, can stop being so high conflict and demanding of the other parent and do their best to put their child's needs first. See you next time.